This is Dr. David Shine, and welcome to Business Law 101. How did you get that patent? Well, you're going to go to the Patent and Trademark Office, the PTO, the USPTO. That sits in Alexandria, Virginia. I lived in the Alexandria, Virginia area briefly in the early 2000s. And lo and behold, the U.S. Patent and Trademark Office moved from one set of office buildings in the Beltway area of Washington, D.C. to another area, actually fairly close to where I was living. So I got a chance to watch that situation. The former landlords for the PTO sued the PTO, claiming that the PTO didn't have a right to move or some weird thing like that. Not sure how that ever came out, but anyway, that's where you're going to go ahead and file your application. Now, I will say that patents and trademarks are normally run through attorneys. The filing of them is fairly detailed. The cost of a patent can be anywhere from $1,500 to over $100,000 in order to put a patent together, particularly for an advanced medicine or medical device. It's quite awkward to get a patent. On the other hand, in terms of trademarks, basically you need to show that it's not infringing anybody else's trademark and that it's a legitimate use. So a good example would be, probably one of the best known trademarks in the world is the Coca-Cola script that says Coca-Cola, the little green bottles, fancy shape to them that Coca-Cola sometimes comes in, all of those things. So those are the intellectual property of Coca-Cola. And of course, Coca-Cola, one of the most valuable trademarks around the world. So what is the value to doing either trademark or patent? And that is to keep the competition from using it. It's easier to move the trademark, to assign it to another business or entity. And then investors like to see the trademarks have already been awarded because it's an expensive and important step. This is Dr. David D. Shine for Business Law 101. If you've enjoyed this episode, we invite you to subscribe on your favorite platform.